In the presence of Mrs. Yamangusho Mercy for the State and Mr. Hamza Chamanya appearing for the accused person, accused through his counsel applied for bail. Counsel appraised court that the parties had since reconciled and that there was an additional statement pursuant to Section 160 of the Magistrates Courts Act. However, no additional statement made by the complainant was produced before this court in support of the submission. Counsel applied for bail for the accused, reasoning that he still presumed innocent. In support of the application, counsel furnished court with 3 sureties who to him would ensure that accused stands up for his trial. The sureties are Mr. Mushawe Daniel Kantayomba, an uncle to the accused person. He is a resident of Sumba Cell, Kisozi Ward, Chengira Town Council in Wakiso District. The role is to keep law and order. Further, that the offense went viral and thus there is public interest, hence may affect public perception about the court. That the public out there is very bitter, while that it would be for the accused's own good if he is denied bail. She prayed bail be denied to the accused so that the inquiries can be completed and the full force of the law takes its course. In rejoinder, Advocate Chamanya for accused submitted all the sureties are of age and all the accused are seen from their respective national identity card and again fully employed. For example, the second surety working with ISO. He also emphasized that the accused and the victim had reconciled, while release on bail would complete the conciliation process. Regarding public bitterness, counsel submitted there was no evidence to that effect, while the law encourages reconciliation. To sum up, counsel reminded the court of the presumption of innocence that is still enjoyed by the accused person until proven or he pleads guilty. He moved the court to be pleased to release the accused on bail pending the hearing of the case. Turning to the merits of this application, indeed, Article 23, Clause 6, Paragraph A of the Constitution provides that where a person is arrested in respect of a criminal offense, that person is entitled to apply to court to be released on bail, and the court may grant that person bail on such conditions as the court considers reasonable. I have made reference to a case of Dr. Ismail Kalule versus Uganda, this criminal business application number 1 of 2018, decision of Muchivi J. Accused in this case therefore has the right to apply for bail, and bail is granted to an accused person to ensure that he appears to stand trial without the necessity of being detained in custody in the meantime. The effect of bail is to release the accused from physical custody, but he is still under the jurisdiction of the court and is bound to appear at the appointed time and date. Again, in granting bail, the court must equally bear in mind the interest of justice and the liberty of the person, because neither ought to be sacrificed at the expense of the other. I am bound by this position drawn from the Honorable, the Principal Judge Emeritus, Honorable Justice James Ogora in Uganda versus Colonel Retired Dr. Kiza Besije, this constitutional reference number 20 of 2005. However, while in as much as accused person has the constitutional right to apply for bail, the grant of bail is subject to some conditions being fulfilled by the person seeking bail. The conditions are set out in Section 77 of the Magistrates Courts Act. They include nature of the accusations, gravity of the offense charged and the severity of punishment which conviction might entail, the antecedents of the applicant so far as they are known, whether the applicant has a fixed abode within the area of court's jurisdiction, and finally, whether the applicant is likely to interfere with any of the witnesses for the prosecution or any of the evidence to be tendered in support of the charge. These conditions have been restated in Ruparelia versus Uganda. In the current case, the court has arrived at the fact that an accused is indeed presumed innocent until proven or he pleads guilty. Again, this is the gist of Article 26, Article 28, Clause 3, Paragraph A. I have rightly captured the submissions of both the land senior state prosecutor and counsel for the accused on both the record as well as in this ruling. I have weighed them against the above considerations and formed my own position guided by the law. In regard to the sureties, I find all the 3 sureties of adult age and also older than the accused person, the first surety being 52 years. The second surety and the third surety are respectively 37 years of age. They were properly identified to court through their respective national identity cards and letters from the area LOC1s of areas of residence. I'm alive to the position in Dr. Kiza Besije versus Uganda, decision of Masal Musene J, wherein it is posited that duty of sureties is not merely to assist the friend or relative to get out of prison. Sureties in this case have a duty to ensure that accused does not abscond. In the event that accused absconds, the sureties must explain to court why the accused failed to attend court. Surety is therefore one of the prime considerations for granting bail. It is submitted by counsel for the applicant that all the three sureties in this court are well aware of their obligations to court, while counsel invited the court to find them substantial. I agree and thus find each of the sureties for purpose of this bail application substantial. In respect to the nature of the accusations, I find the accused is charged with the 2 felonies, although triable by this court. The offense in count 1 involves violence, being assault occasioning actual bodily harm, contrary to section 219 of the Penal Code Act. I note the maximum sentence for each of the offenses in the event of a conviction is 5 years imprisonment. However, they are all bailable offenses by this court, while the accused is still presumed innocent. In regard to the antecedents of the applicant, so far as they are known to this court, there is no evidence tendered before this court showing that the accused is standing trial before any other court of law in Uganda over any other charges, and neither is there proof that he has ever jumped bail before upon release. At least none has been brought before this court. The charge sheet shows the accused is a police officer at a rank of Assistant Superintendent of Police, and at the time of this offense, he was attached to Counter-Terrorism Directorate, Oil and Gas Department, and a resident of Chanja in Nakawa Division of Kampala. It is held by court that the onus is on the applicant to prove that he has a fixed place of abode within the jurisdiction of this court. This has not been, the purpose of this requirement or ground is that the event of accused being granted bail, he or she cannot shift to another place. The accused satisfies this ground on the information furnished to this court by the prosecution in the charge sheet. On the submission by the land state that the offense went viral, and thus there is public interest that may affect the public perception about the court, coupled with public anger possibly over this offense and towards the accused. Although no evidence was furnished to court to this effect, I take judicial notice of the explosive use of social media platforms in this era, where every member of the public freely expresses their opinion over any trending subject. I am also alive to the need to take into account public interest in the administration of justice, including under Article 126, Clause 1 of the Constitution, a requirement on this court to exercise judicial power in the name of the people, but also in conformity with the law as appraised above. While I'm alive to the expressions that may be carried in the court of public opinion over this matter, I shall stick to the demands of the law against the court of justice. Accordingly, all the information placed before me, weighed against the other and bearing in mind the interest of justice in this case and the liberty of the accused person, none of which ought to be sacrificed at the altar at the expense of the other, I'm inclined to exercise my discretion within the context of this case to grant bail to the accused person on the following terms. The accused is to execute a cash bond of 1 million. Further, each of the 3 sureties to execute a non-cash bond of 5 million. It is so ordered until it fulfills the bail terms.
Uganda versus Musinje Barbara.